Okay.
Yes, it is recording.
All right. Well, good evening, everyone, and welcome to this evening's webinar, Is a Will Enough?, in which we'll be covering a range of important U.S.-Israel estate planning subjects. For those of you who've moved to Israel from the States, you'll have experienced many of the logistical and tax challenges of being a dual citizen. A further area that's most sensitive and rife with pitfalls is the settlement of a non-U.S. resident U.S. estate. To address this important subject, we'll have the pleasure of presenting Osher Seaton. Osher has over 25 years of experience and has focused on this cross-border area since returning to Israel in 2007. I would just note from a housekeeping perspective that Osher will go through her whole presentation, and then I will. We welcome any and all questions, but the way to submit them would be through the chat, where our administrator is going to have them and pass them along. So without further ado, Osher, please.
Thank you. And if you also have any technical issues, please feel free to chat with Hilai, and hopefully she'll be able to help you out. Okay, I'm going to share my screen. Ben, is that good? Okay, thanks. So, hi everyone. As Ben said, I'm Osher Seaton. I'm an attorney. I'm licensed in the U.S. For the last 13 years since I came back to live in Israel. I grew up here. I have been working together with Israeli practitioners to serve either U.S. citizens who are living outside of the U.S. or non-U.S. citizens who have assets in the U.S. Of course, I have to make a disclaimer because I'm an attorney, so everything I say tonight is general and is not personal advice to you. So if we're talking about is a will enough, let's talk about what a will is. Okay, so a will is a legal document, and because it's a legal document, it's very important that it meet the legal standards for being a will. So many people come to me and say, I wrote my own will, it's in my handwriting, here it is, or I typed it up on the computer, this is what I want. It's very important to understand that a will is going to be used after you pass away. You will not be able to explain what you meant by what you wrote in the will. So I think that this is a document that should be written by a professional, because it's going to be looked at by legal departments in financial institutions or here in the taboo or by a court. And so it's very important that it be written in a language that the legal departments are going to understand. Another point is it's only used for after death. So any request that you have or instructions that you have for anything that should happen before death doesn't belong in the will. I've seen people often mix up something called a living will, meaning all different kinds of instructions that you have with regard to your healthcare if you can't make decisions, and your will. Your will is really only supposed to be used for explaining what you want done with your property after you pass away, so instructing your inheritance, and also if you have minor children, stating what you want to happen with the minor children, who should raise them, etc., etc. Many people think that if you have a will, it doesn't have to go through probate, and that's how you avoid probate, because you've instructed what you want in your will. But that's really not the case. Probate is the court process by which a will is determined to be valid. If you write a will, a court has to look at the will and decide that this is a legal document that meets all of the requirements of a will. That's what the probate process is. Now, there is probate without a will. A court can decide what will happen to someone's inheritance if they don't have a will, but that's not what I'm talking about right here. So please understand that if you write a will and you intend for things to go through your will, that means that you're going to need probate. Now, if you live in Israel, my general advice to people is to have an Israeli will. Number one, particularly if you have minor children, and if you have minor grandchildren who you want to inherit from you, make sure that you have a will explaining exactly what you want done. But if you have minor children, it has to do with who you choose as the guardians of those children. Okay. Now, before I move on to not residing in Israel, If you reside in Israel, or if you're making aliyah, moving to Israel, immigrating to Israel, then my advice is wait for the Israeli will until you have something in Israel other than just a bank account that you're depleting on a regular basis, because Israeli wills are more expensive than what we're used to in the United States. Of course, everything that I say with regard to Israeli law run by an Israeli attorney. There are many good ones, and if you need ideas of who they are, please feel free to email me after this presentation. I'll be happy to refer you to a good Israeli attorney who can help you. Now, if you do not reside in Israel, but you do own assets in Israel, you own real estate perhaps in Israel, or you have investment accounts in Israel, or other types of holdings here in Israel, it's important to have an Israeli will. It is more important that your U.S. estate plan does not apply to your Israeli assets. Typically, a U.S. estate plan, and we're going to talk about that in just a moment, for people who reside in the States consists of a will that pours over into a trust. If you want your trust to also govern your Israeli assets, you're going to run into a lot of problems trying to implement that here in Israel. It's not a good idea. So it's better to have a separate Israeli will here in Israel. So a question that I get often is, okay, so if I need a will, and by the way, I have not established that yet. We're going to follow through with that question as we walk through this presentation. Do I need two wills? So if you're residing outside of Israel, my suggestion is, as I said before, to have your U.S. estate plan and to have a separate Israeli will that governs your Israeli assets. If you're living here in Israel, you can use your Israeli will to be able to govern your U.S. assets. It depends what your U.S. assets are. So what happens after someone passes away living here in Israel, if they're a US citizen, if they have assets also in the United States? Assets means anything that you might own in the US, retirement, non-retirement. We're going to talk about the differences a little bit, real estate, etc. Your family will go, your heirs will go to the system here in Israel and obtain an Israeli probate order. It doesn't take very long, typically. Okay, and then you can take that Israeli probate order, have it translated. There are other requirements that it has to meet, and then submit that to your U.S. financial institutions to say that the will is valid and that it can be followed. The instructions in the will can be followed. Now, this will work, as I said, for US financial institutions. That includes banks and brokerage houses, and also any individual stocks that you hold through transfer agents in the United States. It is not true for real estate that you own outright, meaning if you own your own real estate and it's solely owned by you, maybe it was jointly owned and the other joint owner passed away, but if it's something that you own by yourself, then there has to be probate also in the United States. So all over the web, we read about avoiding probate, and I'm talking about a lot of probate. So first of all, here in Israel, and again, run this by your Israeli practitioners, but my experience has been with handling many inheritance cases, that in Israel, everything goes through probate except for the things that are listed here, right? The types of retirement plans that we have here, kupot gemel, karnot ishtalmut, different types of pensions, life insurance, okay? Those are things where you designate beneficiaries beforehand, and those do not require an Israeli probate order for the most part. Okay, but everything else in Israel does. And so there's no such thing as avoiding probate here in Israel. And that's okay. The system is a lot lighter and easier than it is in the States. Now, in the States, yes, one of our goals in doing estate planning for your US assets is to avoid probate where possible. But please, it's not the be all and end all. It's not terrible if you cannot avoid probate. And we're going to talk about one of the instances where you may wish to actually initiate probate in the US. Okay, so these are the reasons here on the slide that are real life reasons that can make the probate process in the States a little bit more complicated and costly, right? Global families, meaning if you have heirs in different countries, if you have a decedent, meaning someone who passed away in a country outside of the United States, if you have assets in different countries, right? Those all are all the criteria that make a family a global family or an international family. And that can confuse U.S. financial institutions and courts, and it can take a longer time. I've seen a court take about 8 months to try and compare between an Israeli will and a New York will that were exactly the same and decide that it was okay to implement the New York will. So that's an example of sometimes it can take longer because of this issue of the global family. Now, when you live outside the United States, you don't necessarily have someone who's a layperson in the States who can go ahead and file for probate. And so you may need to hire an attorney to file for probate. The cost is not great, but it is an additional cost. If you do not have a family member who's living in the States, you may need to hire an executor, a corporate executor, who can go ahead and file and be an executor for you in the States, because typically an executor has to be a resident of the US in order to qualify. And again, there are some complex legal issues that can come up with regard to jurisdiction. You can imagine if you're a person who's been living out of the United States for some time, more than, let's say, a few years. And I have clients who sometimes have been living outside of the United States for 40 or 50 years. Then how does a court determine that it has jurisdiction over that estate? Because that person hasn't lived in, let's say, Oklahoma for all that time. But the last time they lived in the States, they were living in Oklahoma. So should we file there? Well, the account that they have is with Wells Fargo. They opened it when they were living in Alabama. So should we open the probate estate in Alabama? Or maybe Wells Fargo is registered in another state. So should we file in the state where Wells Fargo is located? Because essentially all of the business with Wells Fargo has been done online for the last decade. So these are the types of questions that can come up where a court may decide that it doesn't have enough of a connection with the person who died to be able to actually open the probate. So then, even if we can get through this issue of not needing probate, okay, let's say you title all of your assets joint with right of survivorship, meaning when one spouse passes away, the other spouse can immediately inherit by just providing a death certificate. Or let's say you don't have that designation and you're going to use the Israeli probate order, as I said, and it says that the kids all inherit equally. That's what your will says. Well, after you submit all of the paperwork to the financial institution, they are now going to require what's called an IRS transfer certificate. So a US citizen who resides outside of the US, when they pass away, falls under an IRS, a tax code section, a US tax code section, which requires this piece of paper from the IRS called a transfer certificate. It essentially is a release from the IRS that states that no estate tax is due, or if estate tax was due, it was paid. So some people say to me, how are they going to know that I live outside the US? Because I've maintained a US address on my accounts. Well, your death certificate is going to be from outside the US. And when people fill out paperwork, they're going to have to fill out paperwork sometimes by signing before a notary under penalty of perjury that the last place that you were living when you passed away was inside or outside the US. And so these are the types of things that are going to indicate to the US financial institution that you were a US person living outside the US. Now, once you get all the documents, all the information together to be able to submit the request to the IRS for the transfer certificate, which requires a list of all of the assets that the decedent, the person who passed away, owned on date of death and their values on date of death. So that can be quite extensive to obtain. Before the current last 9 months of the COVID era, the IRS was backlogged by about 11 months. And now I currently am waiting for a transfer certificate that I filed for 2 years ago. So we don't know how long the backlog is going to last, but we can assume that it'll last approximately a year, probably more at this point. Please understand that the downside of this is that the asset that is at the US financial institution or with the US transfer agent is frozen until the transfer certificate is provided. So even joint with right of survivorship accounts are frozen, meaning I've had experience with several of the larger brokers and banks that a joint with right of survivorship account between two spouses, one spouse passes away, the other one notifies the bank that the spouse has passed away, they immediately freeze the account. Nothing goes in, nothing goes out, nothing is traded in the brokerage account, and the joint spouse essentially has no access until a transfer certificate is produced. Earlier today, I was speaking with a broker, and they were able to say that so far their platform has allowed the surviving spouse, who is a joint owner with right of survivorship, to obtain reasonable living expenses during the time that they're waiting for the transfer certificate. But that has not been my experience with every financial institution. There are two ways to obtain a transfer certificate. One is the request that I talked about before, and the other is to file an estate tax return. Even if you do not, if the estate does not owe estate tax, there is a possibility that you may wish to file an estate tax return to reserve the credit for the second death. In either case, if you do have to file an estate tax return, or you choose to file an estate tax return, or you don't have to and you just file the request, there's still quite the backlog. So how do we avoid the need for a transfer certificate? You can do so in two ways. If the decedent was a U.S. Citizen, then you can file for U.S. probate. This would be a case in which you wish to file for a petition for probate in the United States. We run into the issues that I discussed before, but it'll probably take a shorter period of waiting than obtaining the transfer certificate will. In addition, you're aware of your costs. With the transfer certificate, it's a little bit open-ended because you'll pay a CPA to put together the request, and then sometimes the IRS requests additional information and some clarifications, and so you'll be paying your CPA additional hours to deal with the IRS and obtain finally the transfer certificate. The other option that you have is to create a trust. And here I'm talking about a living trust. And I'm going to talk about that now. A trust is a contract. Okay. Please note that the type of trust that I'm talking about is not a tax planning vehicle. Okay, so this is not a trust that you would put together in order to deal with exposure to the estate tax. This is a trust that I'm going to talk about the advantages and different disadvantages and the various goals that it will obtain on the next slide. But we need to be mindful that the purpose of this trust essentially would be other than reducing your exposure to estate tax or income tax. Okay. So it's a contract, and it's a contract between the people who set up the trust, who are settlors. Note it's with an O. That's particularly important in Israel. And so the settlors set up the trust. Typically, that will be a married couple can set it up together. If there is one U.S. citizen and one non-U.S. citizen, then the U.S. citizen will set up the trust. If you're single, then it's fine for you to set up the trust yourself. And the contract is between the settlors and the trustees. So again, whoever the settlors are in the beginning will also be the trustees. So it's a little bit of a legal fiction because these people will also be the beneficiaries until the settlors essentially pass away. Okay. So the trustees are the people that you trust with managing all of your assets in the United States that are non-retirement assets. Now, sometimes we will use a trust to cover some of your assets in Israel. I know I said before that you should not do so. This should only be done if you put together with your team an estate plan that calls for that. So please do not set up your trust and start to put your Israeli assets in it. Do not set up a trust and expect to put Israeli assets in it. Only do so if your tax professionals got together and your estate planning professionals got together and decided that that's what should be done. So the trustee essentially is going to be someone after the initial trustees, who are the people who set up the trust, pass away or become incompetent. These are people who you're going to instruct via this contract what to do with your assets. And basically you want them to be able to do everything that you can do with your assets: buy, sell, borrow against, et cetera, et cetera. But you also want to instruct them what should happen with your assets when you pass away, so that they know which child is supposed to get what, whether the grandchildren are supposed to get anything, whether anything's supposed to go to charity. And you can be quite creative in trusts. I have clients who have set up trusts and said, you know what, we want this to be our children's retirement. We don't want them to rely on it during their working lives. So they're going to hold it in trust until the kids are age 65. I have clients who say, okay, I think I'd like them to get it as soon as they get out of the Army, if God forbid something had happened to both of us. And so we'll give them an amount then, and then we'll give them an amount at, let's say, 30 and 35. I have clients who hold it in trust forever and say, look, the money's there if they need it, but I don't really want them to rely on it. So we're just going to have it kind of just in case. And that's a dynasty trust that stays in trust for generation upon generation. So the beneficiaries would be essentially initially the people who set up the trust during their lifetimes, even if they should become incompetent. And then it would be whoever you name. If you have children, grandchildren, wonderful. If you don't and you want it to go to nieces and nephews, that's fine. If you want it to go to causes, that's fine too. I also write in a role into my trust of something called a trust protector, who's able to change the trust after you're not able to anymore, because sometimes tax circumstances change, sometimes family circumstances change. I'm running out of time, so I'm going to try and shorten what I have here, but this will be sent to everyone after our webinar tonight. So the advantages of the trust are, obviously there's no need for a trust certificate. It can provide some asset protection against divorcing spouses of your beneficiaries, meaning not yourselves, but future beneficiaries. It does obviously enable you to control your assets more after death rather than just divvying it up after your death. If you have minor children or grandchildren, it's a wonderful vehicle to be able to provide for them without having an intervention of the court. And if you have a non-U.S. citizen spouse, it enables you to allow the non-U.S. citizen spouse to inherit without exposing them to the U.S. estate tax, because these are U.S. assets, and if they pass away owning U.S. assets, the estate tax is much higher for them. The disadvantage is a setup cost. My office charges a little bit more than you might have to pay if you were paying a domestic attorney in the States to set it up. And that's because we have to put in some provisions for, again, the issue of global families. So if you do decide to go with a preparer in the States, someone who's going to prepare your trust who's in the States, make sure that they are familiar with the international aspects of U.S. law. The ideal estate plan from a U.S. Estate plan point of view includes a U.S. financial power of attorney, which would make sure that you're covered in the event of incompetency. Again, the trust helps with that, but not for retirement assets, so it's important to have that as well. Optional would be this issue of the U.S. trust that we talked about. If you're going to have a U.S. trust, make sure that it is funded during life, which means that you want to change the ownership of all of your non-retirement assets in the States to be owned by the trust during your lifetime. There's no charge for that. There's no tax event for that. It's very, very important to do. It's somewhat burdensome bureaucratically. That's true, because you have to go one by one, but it's incredibly important. Do not set up a trust if you're not going to fund it during your lifetime. You may wish to have a U.S. medical directive that instructs what to do in the event of healthcare issues if you cannot make decisions for yourself and you're spending a lot of time in the States. If you're not spending a lot of time in the States, there's no reason to have one, because in Israel, they're not going to follow it. And here in Israel, as I've explained, you want to have Israeli wills and you'd like to have an Israeli continuing power of attorney. The reason you need both a US and an Israeli one if you have assets both in the US and in Israel is because they do not cross borders. Okay. Please be mindful that some of the issues that local attorneys, meaning local attorneys in the US and local attorneys here in Israel, will not know about are some tax planning with regard to capital gains tax and the difference between heirs who live in the US and heirs who live in Israel. I don't have enough time to go into this at length, but it's quite an issue. And the fact that transfer on death titling does not work if the decedent resided outside of the United States when they passed away. What that means is that if the financial institution finds out that the decedent passed away outside of the U.S. in a country that does not have a transfer on death statute, and Israel does not, then they will refer it for probate. Once again, you can use the Israeli probate order, but you'll run into the transfer certificate issue. So I'm going to close with a few points that hopefully were clear during my talk today. And one is, it takes a team. We've got tax issues involved, so you need your CPAs. We've got investment issues involved, so you need your financial advisors such as Ben. And we've got Israeli and US issues, so you need your Israeli attorney, your US attorney. Sometimes I have clients more and more who have a domestic US attorney, a domestic Israeli attorney, and they bring me in for just the international piece to kind of bring everything together. So although people contact me and say, I just want a will, that's all. And it's simple. We don't have a complicated estate. New clients yesterday talked with me exactly in that language. Yes, you do. Once you're a global family, there are significant international issues that domestic local attorneys are just not aware of. And although it's not going to be a simple process, it should be simplified as much as possible. I hope that I didn't speak over anyone's heads today. If I did, feel free to ask questions in the chat or to contact me. It's perfectly fine. I'm happy to explain things to make sure that you understand them. That's what your professionals should be doing with you. Finally, I am very, very adamant about this piece, because unfortunately it breaks my heart over and over again when people come into my office when mom and dad have passed away and there was not good planning put into place, either because mom and dad didn't think they needed good planning because they just need a simple will, or because they were trying to save money on the planning. Don't, because it will literally run 5 to 10 times the amount that it would cost you to do the correct planning for your kids to pay that on the other end when you pass away. That's been my experience, and it takes years. I've seen estates that have gone on for 3.5, 4, and as long as 6 years to finish up the issues in the states because they were not done correctly. So that is my talk for today. Thank you very, very much for listening. I'm sorry, I'm going to try and stop the screen share. And Ben, it's all yours.
Hello, everyone. I know that Osher covered the, I think, main event of the evening, and but I would like to just review a few other points. She sort of, mentioned, the whole estate plan cross border ends up being, a little more complicated and requires really a team to be able to deal with matters. While Osher was focused on settling the state, in a state in the United States, to the extent that people live in Israel and want to consider bringing assets over here potentially, that has its own set of complications, and sort of both the U.S. and Israel side can have their benefits, but it's useful to have a team, and not only a legal or tax team, but also a financially oriented team to understand really sort of what the benefits are and how those can be integrated in a comprehensive way. So here's a disclaimer that, again, similar to what Osher had said, this is not to be considered to be investment advice, and it's more general in terms of addressing some of the issues. So if we look at the components of a comprehensive cross-border wealth plan, we have the logistics of banking and investing for U.S. expats, and then we have the coordination of multiple tax and state regulations, investment in currency risk management, suitability of local investments and savings products in Israel, and advisor expertise and accessibility. So now I'll just go into some of those in a little more detail. That was just a brief overview. So when one has their investments, it's very important, and sort of a primary principle in financial planning and investment structuring of investment plans is there's a match between the income investments to expenses and liquidity needs for an individual. And so to the extent that a individual, couple, family are in Israel as opposed to be the United States, and they came from the United States, some of the solutions and even underlying investment plans that existed then, or especially also they come from other jurisdictions where even there were smaller local markets, that now we're living in Israel, and it makes sense to have a much broader perspective and view in terms of investment opportunities in the world. The other element of it, aside from, okay, what should my asset allocation be and globally, there's also issues of exchange rates and inflation. And those can be, right now, we're in a very low inflationary environment. We've been in a low inflationary environment, but at times and over time, inflation and exchange rates and interest rates really fluctuate differently in different markets and different currencies and all that. You have to be very mindful of that so that you don't find yourself in a situation where right now, if someone were living exclusively on dollars, their reality could be, depending on sort of their resources and their needs, their reality today could be different than it was in the last few years. And so you really need a comprehensive plan that addresses all of those to manage those risks and opportunities. So then I'll just touch on a couple of logistical issues on the U.S. and Israel side in terms of the banking, right? So Osher referred to the fact that, okay, banks have their policies maybe following their interpretation of the tax codes in terms of their requirements for transfer certificates. But there are many financial institutions, banks and brokerage firms in the United States who don't even want to work with a U.S. expat. So it's very important to find a platform that's comfortable working with U.S. expats. And frankly, one of my main platform, and they're not going to guarantee it, and I'm not going to guarantee it. So this is not an alternative to good planning. I don't want to insinuate that, but we work with a platform where I think they're able to very readily accept the Israel probate, and in fact, allow joint holders to have access to their money. But it's about finding the right institutions to be able to meet your objectives. As you may have experienced, U.S. expats really can't use U.S. mutual funds, invest in mutual funds. So we've designed strategies around that. A mainstay of investment planning in the United States is tax-exempt munis and other tax-exempt bonds and solutions. And once you're a taxpayer in Israel, it really brings into question if those really are appropriate. We mentioned registration of accounts for estate transfer, and then moving to the Israeli side, on the Israeli banks, many of them, they're very concerned after settlements they made with the United States and all of, adhering to FATCA and all. And, different banks and different branches, are more or less familiar with those types of issues. And it's, important to find the ones, the right ones to work with. And then to move from the banks to actually what the investments are. And at this point, I think more and more people hear about them, but many of the Israeli, what would be a tax efficient Israeli investment vehicle, whether it be even a simple mutual fund, really become very tax inefficient for U.S. taxpayers. In addition to that, also many of the just standard insurance savings plans. And you could end up, more than losing the tax benefits you get on the Israel side, you can more than lose it on the U.S. side. But all of these types of things, there are alternatives that make sense and can be used for U.S. persons. I'll just spend 2 minutes now talking about different, sort of exposure. The U.S. has really had recently, the market there has been so strong and people are very focused on it. We think living in Israel, where the local market is so small relative to the global market, that it makes sense to have a global type of an orientation. Sort of the brown G's down the middle, much more, less volatile and steady than being sort of overweight in the United States or being overweight, outside the United States. Another very, I think, timely issue right now is the US dollar shekel exchange rate, and we can see how volatile that could be. And so, it's important to try and figure out, well, how do you integrate addressing that currency exchange rate risk into a plan? Here, this is just sort of for this is euro dollar, but just to give you a sense, the idea is if you looked at the blue line is hedged, right? So if you hedged your exposure and remove the currency exchange rate exposure, you could have a much more a much smoother investment experience, as opposed to if you're having foreign currency exposure. What I would say is that often, especially if you live in Israel, it could be as simple as having the appropriate amount of shekel exposure to meet your near-term needs and sort of to smooth out that experience. So I'd say this, the last two slides. One is, it's very important as part of a plan. I'm sure before you were to meet with any attorney and talk about creating a trust or a will or otherwise, you really have to go through all your accounts and your different structures and insurance coverages, make sure they're all relevant and appropriate to your needs. You have to consider your investment objectives as you've gone through changes in life, whether it be moving more recently or going through different stages, approaching retirement, whatever it might be, to really consider your objectives and for your wealth, if it's transfer of wealth to the next generation. All of those have implications for a plan, also from a tax perspective, also from a legal perspective, also from a state perspective, and also from an investment perspective. And it's very important to work with advisors who are knowledgeable and can work together and to come to the right solution to address your plans. So I guess that sort of wraps it up. Now I think if questions have been submitted, I think we're prepared now to deal with those. Osher, have you gotten them?
Hi, so we do have a few questions. Can you hear me well?
Yeah.
Thanks.
All right, so we do have a few questions. We have a question about assets in other countries besides U.S. Israel.
So Ben, I think that one's for me. Okay, so it depends on the country. Many countries that I have experienced in Europe. I'm trying to think where else. Will accept an Israeli probate order. The financial institutions there will accept an Israeli probate order. Canada needs particular planning. The UK needs particular planning. And so far, those are the different countries that I have dealt with. If you have assets outside of Europe and North America, then you probably want to consult a professional who's in that country so that you can find out.
Right. Another question is, what are the consequences of being a trust beneficiary? Someone mentioned that a few years ago, maybe there was a new law imposed consequences on all beneficiaries of the trust, so long as one of them was Israeli.
So the Israeli trust tax law that was changed a few years ago does not have to do with trusts that are created by a person who is residing in Israel. Okay, so in other words, I live in Jerusalem. If I said I'm a U.S. citizen, if I set up a trust similar to the one that I was talking about before, that trust is going to be taxed by Israel anyway. Does that make sense to everyone? Because I live in Israel, so I'm taxed. And if I'm taxed and I set up a trust that's essentially transparent, right? I'm the person who set it up. I'm the person who's managing it. I'm the beneficiary to begin with. Then that trust is going to be taxed by Israel. It's going to continue to be taxed by Israel after my death, because when I passed away, I was living in Israel. And there are ways that we can carve out parts of it to no longer be taxed by Israel, but that has to meet certain requirements. Okay, and that's one of the reasons that we work with Israeli tax professionals to make sure that we are structuring the trust correctly, so that if we can reduce tax to it, we will. Now, the particular trust tax law that was mentioned has to do with trusts that were set up by people who do not live in Israel for Israeli resident beneficiaries. So let's say Ben and I are dealing with that type of trust right now, right? Let's say grandma set up a trust for grandchildren, and one of the grandchildren, and grandma lives in the States. Grandma has always lived in the States, and one of the grandchildren moves to live in Israel. Okay, again, we need to bring in an Israeli tax professional to review that trust and to make suggestions as to how to reduce the potential Israeli income tax exposure to that trust. And that Israeli tax professional will make those recommendations. And then someone like me, in other words, a U.S. Trust and estates attorney, will make changes to the trust in order to reduce the exposure. Hilai.
Yeah. Another question is, does the size of the estate make a difference in planning?
Okay.
As a smaller estate, does it not justify trust?
Great. And Ben, you and I had talked about that one.
Yeah.
So I'm glad it came up. I forgot to mention I was going to. So my experience is it depends on your motives. Okay. There's certainly a cost benefit analysis here. It's going to cost you a few $1,000s to set up a trust. And so it's up to you. I have set up trusts for as little as a couple $100,000. If you feel strongly that the goals that the trust will accomplish are your goals, then the trust is the right way for you to go. In the long run, there's no additional operating costs to the trust. Okay, so in other words, if you name as trustees people whom you trust who are not going to charge the trust for being trustees, then there's no operating cost there. It's not a more complex tax return than you're already filing for yourself. So that's not going to be an issue. There can be additional income tax consequences, but typically there isn't if you have good advisors who are advising you on how to manage the trust. So I don't think that there is too low an amount. I think it more has to do with, is the trust the right vehicle for you? Is it going to accomplish your goals?
Another question is, why can't expats own a U.S. mutual funds? Own U.S. mutual funds.
Right. So that is, and it's probably both on through the U.S. brokerage firms as well as the mutual fund sponsors. I would say there's probably two reasons. One, I think that in general, and part of the reason that a lot of financial institutions don't want to work with American expats is that if you have a foreign resident, it increases their compliance costs. Another reason that some have suggested to me is that there are tax treaties. Let's say you want to own Nestle's in a U.S. fund, and well, they have a tax, and they don't want to have a withholding tax. So they basically assert that 95% of our holders, or whatever it might be, are U.S. residents. So I've understood that some managers, it's a matter of making sure they don't run afoul of that. But it's pretty much down the line. I mean, there may be a few exceptions if you work with particular managers, but all the experience I've had is that you're not able to. Now, just to spend a half a minute on it, right? So, in the last 10 years, there's been the advent of ETFs, which are exchange traded funds, which for all intents and purposes are U.S. mutual funds. And in fact, they also happen to be lower cost and more tax efficient. So it's an easy workaround, especially for sort of passive strategies. And really, our strategies are really built on those. And sort of it's really, frankly, a better mousetrap.
One of the ways to get around that, sorry, Hilaya, we'll move on to the next one in just a moment. One of the ways to get around the difficulty that people are having with their brokers in the States, there are two ways actually, Ben, because you and I talked about one way that I definitely wanted to bring up. One of them, again, I know I sound like a broken record, and I'm sorry, is a trust. If you put everything into a trust, then typically they will treat it as a U.S. entity because the trust is is considered a U.S. person, and is essentially, quote, located in the U.S. from a legal standpoint. And so many brokers will be very happy if you decide to change ownership to a trust. The other way, Ben, is one of the things that you and I talked about. Do you want to talk about how you can manage investments in U.S. Mutual funds, et cetera, through Israeli institutions?
Well, okay, so I think what Osher is referring to is there are some small number of sort of U.S. compliant investment sort of tax advantaged investment vehicles. Here in the market, they would be called an IRA. Now, you shouldn't run out and just go to your lowest, nearest insurance broker and buy that insurance company's IRA, because all but one that I know of are not compliant. But there are options locally. I mean, what's interesting is that, in fact, so most of the large mutual fund companies will manage onshore, meaning US funds, and then they'll manage offshore. As I mentioned before, you don't ordinarily, an individual US person doesn't want to own an offshore fund because it's a PFIC. That said, if it's owned through one of these types of a wrapper, then those are all available to you. And those can be, really, just broadens the range of things one could invest in, especially, outside of the United States. So we manage a number of those strategies, those types of accounts as well.
Hilai?
Yeah, another question is, what are the cost parameters of a comprehensive plan?
Wow. So it really depends on the complexity of your particular circumstances, right? And so we're talking about having a U.S. attorney involved, either someone who's domestic or someone like me who has the international aspects as well, international practice as well, and having an Israeli attorney involved. And you may have to turn to your CPAs for some questions during the process, and also have your financial advisor involved. Okay, and so the cost can run as little as less than 10,000 shekels, and the cost can run way more than that, depending on the complexity of the plan. And it also depends on what you choose. I tell clients all the time that there are essentially three phases to the estate planning process. One is, Ben talked about it, collecting all the information on everything you own. It's extremely important to have that list. Okay, time after time, I have children who come to me and say, we don't know what dad owned. And then they have to spend months, if not sometimes years. I had an inheritance case once where 4 years we had been working together. Again, one of these complex cases in the States where there was no planning. And after 4 years of working together, the family came across yet another account, and that we didn't know it had existed until then. And so it's very, very important to put together a list of what your assets are. So that's phase one. Phase two of your estate planning process is to do the planning. And that is to sit down with your professionals and have long meetings with them. Okay, typically a meeting with me lasts at least an hour and a half. Sometimes it can last as much as 3. Sometimes we have to meet a few times because you have to go back and ask some questions of other professionals or consider things and then come back to me. And so it's a long process. And then also sit down with your Israeli estate planning professional. And putting together an Israeli continuing power of attorney over and over, I have heard, can take several hours. And so it's a commitment. It's a process that's a commitment. And that's phase two, and that's putting together the estate plan and deciding what you want. Do you want to have joint with right of survivorship titles for your assets in the States? Or do you want a trust? Do you want a will? You can do any of them. It's not that you can't do them. There are pros and cons for each one. And so clients of mine who own assets, for example, in the States, non-retirement assets that are only $100,000 or $200,000, and they have everything else in Israel, or they have them scattered around the world, but an Israeli probate order will be sufficient, say, so it doesn't matter if they need a transfer certificate. I'll title everything joint with right of survivorship, but I'm not going to set up a trust for that amount of money. So every family decides what's right for them. And so that's phase two. And phase three is then the implementation. So if you are going to go the route of joint with right of survivorship, make sure everything is titled joint with right of survivorship. If you're going to go the route of a trust, we need to set up a trust and fund it. If you're going to go the route of a will, we need to make sure that your will is going to be comprehensive and do what you want it to do.
Another question is considerations for transferring substantial amounts of money from U.S. to Israel. And are there IRS forms? Or is that a different question?
No, that goes together. That's fine.
Okay.
Thank you. Ben?
Right. I mean, yeah, I'm not aware of any there's not, I'm not aware of any IRS rules. The hurdle is to get the bank comfortable that the money was taxed. So it could be a letter from a CPA, some other proof. So to the extent that things are simple and the provenance of the money is easy to prove, then it's, quite a simple thing. If it's a little more convoluted, then it could take a little more time. But that's why it's also important to work with a branch or a bank who, is amenable and familiar with things to, get things done. But, yeah.
Absolutely.
Another question is holding on to cryptocurrencies regulated or restricted by Israel?
Oh, Ben, do you have any experience with that? I can't answer on the Israeli
Wait,
side.
could you repeat the question?
Yeah, is holding cryptocurrencies regulated or restricted by Israel?
Not that I know of. I'm not, there's a lot of different platforms out there. I'm not aware of any.
I believe that the Israeli tax authority has made certain decisions with regard to cryptocurrency in the last few years. So you certainly want to consult with your Israeli tax professional. With regard to estate planning involving cryptocurrency, we need to make sure that we include that in the estate plan. It's very important.
Another question is someone says, my spouse, minor child, and I are U.S. citizens. We're here in Israel on a work visa. The vast majority of our assets are in the U.S. Would a U.S. will be sufficient for us?
Okay, that's a great question. It really depends on how long you're going to spend here. If you're here for what you would consider a short time, then my experience in Israel is, yes, you can use a U.S. will, but once again, you really need to sit down with good professionals because it depends on what your will says. If your will says that everything goes into a trust, no, don't do that. And you want to make sure that you have provisions in your will for your minor child. God forbid something happens to both of the child's natural parents. You want to make sure that you're appointing a guardian and explaining why you want that guardian. I would assume that that guardian probably is not located in Israel, and Israeli courts, from my understanding, generally tend to want to keep kids here in Israel. So, I think that's a very good case where you want to sit down with a good Israeli professional and make sure that what you have is going to work here while you're here. Again, depending on whether the length of time that you're going to be here in your eyes is sufficient for you to do some planning.
Another question is, can you access the assets in the trust during your lifetime if you need those funds after you have set up the trust?
Absolutely. It's as though the trust doesn't exist. Okay, you're just retitling it instead of it saying Osher and Ben on the account. It's going to say the Osher and Ben joint revocable trust. That's it. That's the only difference. You'll need new checkbooks.
Oh, sure. Maybe just spend a half a minute sort of contrasting a revocable from an irrevocable. Like, I think generally most people are probably familiar with more irrevocable that are done for estate planning and lack of control.
Okay, so the type of trust that I'm talking about, a living trust, first of all, feel free to Google it. You'll find a lot of information on the web about a living trust, okay? But basically, it's a trust that during your lifetime, okay, it is completely transparent. It's what we call a pass-through. So for tax purposes as well, there's nothing special about it. Also here in Israel, you'll contact your Israeli CPA if you're even if you're within your 10 years, you'll need to talk with an Israeli CPA if you set up a trust, because typically they want you to at least register it. But once you've registered it, my experience is you'll be able to declare all the income on your own Israeli ID number. And so that's the type of trust that I'm talking about. When you're setting up a trust for tax purposes to help you with estate tax planning purposes, you typically set up a trust that you have no control over. Okay, that's very different than the type of trust that I'm talking about. That type of trust is a trust where you are the settlor, you set up the trust, but you're not the trustee and you're not the beneficiary. Rather, someone else will serve as trustee. Maybe it'll be some of your kids, maybe it'll be a sibling, maybe a trusted friend. And your beneficiaries will typically be either your spouse or your children or your grandchildren. Some of you might have what's called a life insurance trust. The irrevocable life insurance trusts are those types of trusts. Eli?
Yeah. Another question is there a one-stop shop office that deals with both sides of the equation?
There are a few in Israel. There are very few practitioners in Israel who do what I do, meaning the U.S. international aspects of estate planning, or the fancy schmancy name for it is the U.S. International Private Client Law. We're about 10. We get together every once in a while and discuss various cases so that we could see, you know, if there's any solutions to some of the more complex cases. Not everybody's practices all overlap. And so even though there are 10 of us who generally do that, there are fewer who deal with certain issues. Some of those people, very few, less than a handful, are both U.S. and Israeli practitioners. And so there are some out there. Eli.
Someone asked non-citizen spouse and U.S. estate taxes.
Okay, sure. So we're coming just about to the end of our time, so I'm not going to go into this extensively. I just spoke today, and I just did an interview today that's going to be out on YouTube in a bit, and I can send. I'll probably put on my website the link as soon as I have it. It'll be in a few weeks, and we talked at length about this issue. Bottom line is, unfortunately, when we're talking about a U.S. citizen and a non-U.S. citizen, spouses who are officially married, we've talked a lot about spouses. You must be officially married with a marriage certificate. If you are not, then the federal tax system does not recognize you as married. Okay, so common law spouses or people who were just married in a Jewish ritual, not sufficient for any of the benefits that go between spouses. Okay. Anyway, U.S. citizen spouse married to non-U.S. citizen spouse, we unfortunately have to talk about who dies first. So if the non-U.S. citizen spouse dies owning anything in the United States and leaves it to their U.S. citizen spouse, no estate tax. Okay. If the U.S. citizen spouse passes away and leaves everything to the non-U.S. citizen spouse, if the U.S. citizen spouse had more worldwide on date of death than the current exemption from the U.S. estate tax today in 2020, that is $11.58 million, soon to go up in a few weeks in 2021. However, in 5 years, okay, at the end of 2025, it will go down to somewhere between $6 and $7 million. And so if you're a family where the U.S. citizen spouse owned more than the exemption amount on their death and they leave everything to their non-U.S. citizen spouse, then there will be an estate tax at first death. Let's say that not all of us are that high net worth. And we leave everything to our non-U.S. citizen spouse, and including assets in the United States, including retirement and non-retirement assets in the United States. Okay. Upon the death of the non-U.S. citizen spouse, and they now own a whole bunch of stuff in the United States, the U.S. estate tax will apply to whatever they own that's in the U.S. Now, I'm talking very generally here. Okay. What's defined as in the U.S. will be any shares, any U.S. securities. So if they have a Bank Hapoalim brokerage account and they moved everything to that account and now they own their U.S. securities through the Bank Hapoalim brokerage account, that will count upon their death. Okay, and so it's a complex situation, and I'm saying it in a very concise manner today. Unfortunately, the exemption from U.S. estate taxes for a non-U.S. citizen is only $60,000, 660. And that's not per assets, that's overall. So whatever the non-US citizen inherited from the US citizen and dies owning, that is US connected, if it's more than $60,000, the estate tax will apply. And the estate tax is a double tax. It's a tax on the entire asset value on date of death, not just the increase in the value, not just the income. And and above the exemption, the tax is at a rate of 18%, 1/8, and it quickly goes up to 40%. Okay, and it has to be paid within 9 months of date of death. So you must have liquidity. Often non-US citizen spouses, if there has been no estate tax planning, there's probably been no estate planning, and they will not have, again, the assets in the States will be frozen and they will not have access to those assets in order to be able to pay the US estate tax within 9 months of date of death. And so these are all reasons that we need to make sure if you're a US citizen spouse married to a non-US citizen spouse, it's a more complex situation, make sure to have the right planning done. Ben, did you want to add to any of that?
Well, I would say war stories. I spoke to a CPA who, a couple, the husband was an American, the wife was not. And he transferred all of his assets to his wife. No one told her to sell them and, sell all the US stocks and put them into non-US securities. And then basically the children lost 40% of the estate to the tax.
Yeah.
It's an important thing to take care of.
So Hilai is telling me that we have 2 more questions. So Ben, I think we'll take those and then we'll close up.
Right.
Is that okay?
Yeah, perfect.
Go ahead.
All right. If a U.S. will can be contested by heirs, can living trust be contested as well?
Yes. Yes. If there's a concern in the family due to family dynamics that there is going to be a contest, then we put very specific provisions into the will and into the trust in order to try and prevent people from litigating. We cannot, it's not foolproof, but we can certainly put provisions in. I used to litigate cases in the United States before I moved back to Israel, and I highly recommend against it. The only people who benefit from litigation in estate and trust and guardianship type cases are the lawyers. Hilai.
Last question. If you have a will that was set up many years ago by an attorney for the States and here in Israel, and you just want to change the executor, do you need to do a new will, or can a letter be attached to the existing will?
So that question has many parts to it. If you have a will that is several years old, go and get a new will. It's time. If you have a US will that you want to try and use in Israel, go and get a new will. If you live in Israel, it's time. If you want to change the executor to your will, no, it's not sufficient to just attach a letter. You must do it according to the requirements of the law as to what an amendment to your will is supposed to look like. That's called in legal terms a codicil, and you should go get it done correctly. Ben, any closing remarks?
No, I think that's it. I'd really like to thank everyone for joining. I hope that you found it helpful. We'll be sending out the slide decks, and what we're going to do with the recording. Are you going to post it, or are we also going to send that out, Osher?
Yeah, I'll try. I'm going to try and get it up to the cloud and be able to send out a link for everyone.
Okay, terrific. And we're both available and happy to answer any follow-up questions. If you need introductions to other types of professionals that can, help in this way, we're happy to help in any way we can. So have a great evening, everyone. Bye-bye.
Wonderful. Thank you all very, very much. Thanks, Ben, for doing this with me.
Thank you.